All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, there's our live studio audience, 540-0580. If you have a legal question, call in. We'll answer it here on the air. I've got Steve Snyder floating around here this afternoon. Steve, what's up, brother?
Carl, how are you? Hey, listen, I just wanted to say that I'm calling in from the Cigar Club in Carlisle, and you started a little bit of a situation last week, I understand, when a gentleman called in and asked you where you bought your cigars.
Well, wait a minute. Wait. Let me tell my story. I'll tell this story. You're not going to usurp it. I know how you go, Steve. Steve's trying to steal my thunder. Here's what's going on. Last week, some caller called in and said, "Carl, what kind of cigars do you like?" And I, yada. And then he says, "And what's your favorite shop?" And I'm like, yeah. And I named a few. And okay, so somewhere along the line, I forgot to say the tobacco company in Lemoyne. And one of the owners there, John, who claims to listen to the show, but it turns out obviously is not lying about that, felt slighted, kind of like a teenager, who didn't win a prize at the fair or something. So as a result, I have a plan, Steve, and I posted this on Facebook last night. Today at 3:30, I'm driving over from the WHP studios at the legally posted speed limit, not a mile per hour faster, to Lemoyne. And the address over there is 829 State Street in Lemoyne, where the tobacco company is. And I'm going to smoke a cigar at 3:30, probably a great, big, huge one, okay?
Yeah.
And I want any listeners who smoke cigars, who think they want to try a cigar or whatever, come on over to Lemoyne at 3:30 and smoke a cigar with me. And my goal here is since he was whining about, who was there or not there or what was going on, my goal is to overwhelm him with a smoke-in and take up all their regular seats.
Okay.
So if you know anybody that smokes cigars, Steve, for instance, let's get him over to Lemoyne this afternoon at 3:30 to join me for a smoke at the tobacco company.
Sounds good. Now, I want to say I also buy my cigars at the Tinderbox on 2nd Street in Harrisburg as well.
Oh, no. Now it's all this stuff going.
I think we've covered all our bases.
But anyhow, Steve, you're going to help me with some legal questions today, I hope.
Sure am. Looking forward to it. All
right, 540-0580 if you want to get your legal questions answered. And, of course, at 3:30, I'll be over in Lemoyne at the tobacco company smoking a cigar, and I want as many listeners to join me as possible because I want to make a point. I want to make a point to these guys. Jim, you're on the air. Hey,
Hello?
Jim.
Go ahead.
Yeah, Jim.
Hi, Carl. Thanks for taking my call.
Not a problem. How are you?
Good. Hey,
hi, Jim.
Hi, is it Steve?
That's Steve. He's ruining our flow.
Okay. Hey, guys, I'm involved in a civil suit. 2 weeks ago, the judge dismissed the case because the plaintiff's attorney didn't show at the hearing, said he could refile the complaint if he chooses. Now, he refiled the complaint. That takes it past the statute of limitations. And is it worth my while to file a motion to dismiss?
Yeah, if it's dismissed without prejudice, you can refile it. But if it's filed after the statute of limitations, there's no tolling there.
Even though the judge said he could refile it?
Well, he's right. The judge is right. He could refile it, but that's not going to extend the statute of limitations. So if the judge literally dismissed the suit and it's a dead letter. Now, if they dismissed the complaint and gave him leave to refile it within, so for instance, if it was a set of preliminary objections and the judge said, I'm sustaining the preliminary objections if you don't file an amended complaint within 20 days, but that's not technically a dismissal. It's going to become a dismissal. So if it's literally dismissed, that kills the statute, my friend. You got a winner chicken dinner.
Well, in the letter the judge sent me, it said, I have dismissed the complaint. However, he may refile the complaint if he chooses with specificity.
Ah, interesting. All right. Is this in the common pleas level?
Yes.
And when you call it a letter, you mean like the judge's opinion maybe or order?
Yes, the judge's order.
And it says now this blank day of blank, plaintiff is dismissed or could be filed with more specificity within X days?
Yes, that's exactly the letter I received.
So you're probably not going to be able to win on the statute of limitations because it doesn't sound like he's literally bumped out of court as long as he amends it.
Okay.
However, you or your attorney can file preliminary objections and raise that as an issue. The other thing is I've been in a lot of different civil cases where different things have happened. I've been to civil cases where the opposing side did not show up, and the judge actually gave a judgment in favor of the party that showed up, at which case you have to file an appeal. So you never know what you're going to get with this.
Yeah, and just a clarification, statute of limitations is an affirmative defense, so you'd have to raise that by answer. You can't demur on that because it requires factual proof.
Okay. I did intend to answer. I will answer the new complaint, but I just wondered if it was worthwhile to put in there a motion to dismiss.
Well, yeah, we should always raise affirmative defenses. In other words, after you answer paragraphs 1 through 20, denied, admitted, conclusion of law, blah, 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 blah. New matter would include plaintiff's claim is beyond the applicable statute of limitations. Now, as long as they filed their writ before it and or the complaint and the litigation started, that will save them. But it's worth raising just in case there's some colorable issue. Also, it's worth raising because we do have a doctrine that it's called the gist of the action. And that's the idea that even though a lawyer might, I'll give you an example here. The lawyer calls it negligence, right? He says, count 1, negligence, and then he pleads something. And the court goes and says, well, actually it isn't negligence. It's really more a contract action. Well, that would make a 4-year statute of limitations instead of a 2-year statute of limitations. But imagine it in reverse where the lawyer calls it contract, so he files 3 years in thinking he has a contract claim, but really all he has at best is some kind of tort or negligence-style claim or trespass claim that has a 2-year statute of limitations. So raising it as an affirmative defense is important because a really crafty lawyer who realizes a mistake later but sees that you did not raise the affirmative defense, when you try to bring it up later, he'll say, Judge, the pleadings were closed, and he never raised that affirmative defense, and we're all the way down to trial now, so I relied on that. So, as a rule, you should always raise statute of limitations as a defense in a new matter in answer to a complaint. And actually, all the insurance defense lawyers out there, I'm sure one will call in, they want to talk about this, but almost every insurance defense lawyer in every litigation piece I see pleads every known defense, boilerplate in their answer, almost fraudulently. But they do just in case any of them are applicable. That way, nobody can ever go, well, you didn't raise it.
Okay. So it makes sense just to make the motion whether or not you win or lose that.
And it's not a motion, it's an affirmative defense, it's an answer to the complaint. So in other words, when you answer the complaint and you say yada, 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 then you would add a new matter and say defendant should prevail and plaintiff should lose because the applicable statute of limitations has expired.
Oh, okay.
All right, my friend.
Are you representing yourself, John?
Yeah, because it's such a small amount that it's not worth hiring you guys because I'd end up paying you guys what I would win.
Yeah.
We're talking about $2,000.
Yep. That's in the small range. You're right.
Yeah, so it's on that borderline between do you hire an attorney and take your chances, or do you just defend it yourself and take your chances?
Sure.
All right, Jim. Good luck.
Okay, guys. Hey, I appreciate your show.
Not from. Hey, thank you. 540-0580. Carl Rominger here answering your legal questions. I'm joined right now by Steve Snyder, one of the lawyers in my office. If you want to read Steve's bio, you can go to romingerlaw.com and learn a little bit more about him. Dwight, you're on the air with Carl and Steve. Dwight.
Hello.
What's your question?
Dwight.
Oh, okay. Thank you for taking my call. My son just finished up a Chapter 13 bankruptcy payment, and he got a 1099-A from the IRS for an income property that was put into that Chapter 13 bankruptcy. And just trying to figure out what this means and what to do with it.
Well, here's the easy answer. He must have a bankruptcy attorney, right, who did the 13?
Yes.
I would take it to them and ask their advice on it. If on the other hand, they don't know the answer, my thought on the matter would be, because it's just impossible for me to answer this because I don't know how they structured the bankruptcy. In other words, I don't know everything that was done or not done, what was listed, not listed, how they broke out the different exemptions, properties, what the plan was. And so since a Chapter 13 bankruptcy really is not a boilerplate, each one's created to the individual situation. How that will play out will depend on how things were done in the first instance. Second of all, if the bankruptcy attorney's scratching their head, it might be time to talk to a CPA.
Now, Carl, let me ask you a question. If a debt is written off in bankruptcy, does that become taxable income?
See, that's an interesting question. Sometimes yes, many times no.
Yeah.
In fact, if you're insolvent, then the write-off of a debt is sometimes not taxable, even if you're not in bankruptcy. But here's the answer, Steve. I'm not a tax lawyer. I'm not a CPA, and I don't know a lot about that stuff, except to know that I don't know enough. And that's why I tell people to go talk to the tax lawyer or the CPA, because the CPAs usually know more about tax than any lawyer ever will, and they know a lot about the laws that applies to that area, too, more so than any other lawyer ever will, except for a tax lawyer.
Yep.
All right, Dwight?
Thank you very much.
I know it's not the great answer. It's not the great American answer, but it helps, I hope.
Thank you.
Point you in the right direction anyhow. 540-0580, Carl Rominger and Steve Snyder answering your legal questions. Call in. We'll keep answering them here on the air. And, of course, don't forget to join me in Lemoyne at the Tobacco Company today at 3:30. We'll be back after break. Welcome back. Carl Rominger here answering your legal questions, 540-0580. And don't forget, you can get your free will kit. That's right, a free will. Go to weekendappointment.com, fill it out, send it in. I will sit down with you and write a will. We'll also talk about advanced life care directives, i.e. living wills, and we'll talk about powers of attorney with you as well. We'll also kind of just do a little thumbnail sketch of your estate plan to determine whether or not you can just ride with a simple will or you should be thinking about some more esoteric vehicles. And let's see who's next on the call block here. 540-0580. Steve, you're on with Carl and Steve.
Hi, Carl. Hi, Steve.
Hey, Steve.
Got a question for you. I had a district justice hearing this past week in front of a district justice. I was the plaintiff, and I lost the case when I went in there. I brought in as much documentation as I could to support my case when I went in there. The defendant, who basically lied the whole time he was there, had no documentation to back his part up on what he was saying. But I told the district justice that I could probably obtain the information, if they were giving me another time for another hearing or anything like that. Mm-hmm. So I lost the case. My question is, isn't the district justice supposed to put down the reason that you lost the case?
The answer is they don't have any requirement to write an opinion or any particular answer. They're not a court of record. Mm-hmm. You automatically have a right of appeal of 30 days.
Right.
And that's your remedy.
And you would have to hire a lawyer for that, too?
The answer is, are you the plaintiff or the defendant?
I'm a plaintiff.
You're the plaintiff. So, what happens is once you file the appeal, then you'll have 20 days to file a more formal complaint. I mean, you can certainly do it on your own, but I don't recommend that.
Yeah, because it's not a whole lot of money. It's less than $2,000. And for me to hire a lawyer to go ahead and do that, it's probably going to cost me a lot more.
Yeah, I'll tell you the other thing is sometimes, and this is something I'm always interested in looking at, sometimes if somebody has a claim like that and you say, well, I'm just going to let it go, I've looked at clients before and said, okay, you got a $2,100 claim here. I'll split it with you. In other words, if I think I can collect it fairly simply, I'll split it with you, and that way you still come up ahead because you were just going to throw that money away anyhow. Yeah. But a lot of times guys come in like that, and then they give me that proposition, or I give it to them, but I look at it and say, this isn't a very collectible debt because it's a deadbeat on the other side, so even if I split it with you and get the judgment, we're not going to collect it.
Well, I'll tell you what's kind of unusual about this situation. I got the judgment the following day, and I've been to the district justice many times. Mm-hmm. I've never got a judgment that quick the very next day like that.
Yeah, well, I mean, the answer is some district justices kick them out immediately, some don't.
Yeah, some of them will give you the decision verbally there. Others will say, well, you'll hear from me within a week.
Yeah, well, she told me she would hear from me in a couple of days or something, but I got the judgment the very next day. But the funny thing was that when I was in there that day, the mailman was already in there collecting the mail that morning when I was in there, and he left. Yeah,
that's it. Well, I mean, maybe they walked it.
It's kind of a funny situation that they got that letter out that quick like that.
Steve,
like they already had the judgment already made up.
Steve, let me tell you something. It's funny you say that. I drove all the way to Clarion one time, okay? Mm-hmm. Because I had a speeding ticket out there, and I decided I was going to go fight my speeding ticket. So I'm driving out Interstate 80 to get out there, and there's a major snowstorm coming through the state. And as I get about, just past the State College area on 80, it's bogging down slower and slower. My hearing's at 2 o'clock in the afternoon. I go and I call them, and it's now 1:45, and I'm getting off the exit, and I'm still, a few miles away and plowing through the snow. And I'm going along, and I get there. Now, here's what's important. When I get there, it's now 2:15 past the hearing, and the judge says that he held the hearing in my absence, and I was convicted, right? Mm-hmm. But there's a strange phenomenon. When the snow is falling, it tends to accumulate on the ground, and you can see something called tire tracks in it. And I'm like, that's strange, Judge. There's 4 inches of snow in your parking lot, and I'm the only set of fresh tire tracks that came in, and it ain't falling at 4 inches an hour, buddy.
Well, that's the same situation with me. You know, you kind of like the mailman already took the mail that day. If he would have picked the mail up the following day, I probably would have received it, maybe like 2 days later or something like that.
Yeah, but you know what? Here's the answer. It's either a grand conspiracy or it isn't, but you can file the appeal, and that fixes it.
Well, I'll tell you one thing I was going to do, though. I was going to go down to the Pathonetary and kind of check down there and see if this company has been sued by other people under the same district justice and find out how the outcome's been with them. If they have in other words, like a pattern with the same individuals going in there under the same district justice and the same things happening over and over again, that could, there might be something.
Well, you might be onto something, but then again, like I say, listen, I always say this: paranoid people have enemies. So you might be right, you might be wrong. But listen, I don't know about you, but I don't have that kind of time.
I got the time and I got the money to do it.
Right. Well, that's what I mean. And if you got it, God bless you. And if you find something, go to the judicial board.
Oh, I will. I'll take it to the district attorney. But it just really irritates me, when you go into a courtroom like that and a person comes in there and lies through their teeth like that, and then the next thing is kind of a slap in the face. You lose the hearing and you get the thing the very next day after you see the mailman.
Yeah, Steve, I told you I have listen. I'm not telling you you're crazy. I just told you I had a similar experience where there's no way what the court was telling me happened could have possibly ever happened.
That's the same situation.
And I had words. I had words.
Did you end up?
I filed the appeal and I won it.
Did you?
Yeah, of course. But I had to drive back to Clarion again.
I'll see what happens.
All right.
Might have to do a little checking around, but I'll see what happens.
All right, brother. 540-0580. Tom, you're on the air.
How you doing, Carl?
Good. How are you?
Real good. Hey, I was called you at the end of the show last week, and you were talking about bad debts.
Yeah.
I had a credit card. I'm back up. I'm getting letters from a collection agency for a bank that supposedly I had a bad credit card at, and it's been at least 10 years. Now, I've never had an account with this bank, but I know how people buy and sell debt, so I don't know if it was transferred from another bank or a merger or whatever. But, I keep on getting letters. Now, the original debt was probably $10,000. Now they're telling me it's $35,000, and they're willing to sell it for $6,000.
And when was the last time you made a payment on it?
Well, it would have been at least 12 years ago.
Yeah, so it's outside the statute of limitations.
Exactly.
Can they keep on sending me letters like that?
Oh, I guess anybody can send you a letter. Now, under the Fair Debt Collections Practices Act, I think if you dispute the debt, they have to stop sending it because the debt. But I'm unclear on one thing, and I don't know the answer to this. What I'm unclear on is this: is it really a debt once the statute of limitations goes by? And the answer is theoretically yes, because you could reaffirm it, you could make a partial payment on it. If you dispute the debt and say it's uncollectible because it's beyond the statute of limitations, I don't know what the Fair Debt Collections Practices Act does to that person if they try to contact you again. I don't know the answer to that.
The other thing is, it's never appeared in my credit report, so I don't care.
Right. I guess if we wanted to figure that out, why don't you post that on weekendappointment.com?
Okay.
And one of the guys will take a look at it because maybe we can figure out how to get some money out of these guys.
I'm for that.
Hey, that's one of my favorites. I had a contract one time where some guys came to me in a business dispute, and they said, well, we think we owe this guy $20,000 because he's demanding it, and here's the contract. And it was 3 partners, and one of the partners didn't want to have a lawyer look at it. He just wanted to pay the money, and the other 2 guys said, well, we should have a lawyer look at it. And when we were done, the other guy ended up paying them $25,000, and I only had to write 2 letters. And my point on that is sometimes when people come to collect money, what they don't realize is if you look hard enough and close enough, you might figure out why they really owe you instead of the vice versa.
Uh-huh.
So who knows? Maybe we can find something.
Yeah, the other interesting thing on that the Fair Debt Collection Practice Act is it's a very specific act in what debt collectors can do and not do. And if they violate the act, an example of that would be if you retain an attorney and you inform them that you have legal representation, they have to immediately stop contacting you. And if they violate that, you're actually entitled to treble damages. That means 3 times the damages. And so that act is very, very protective to the consumer, to the debtor, and can really work to your benefit.
Okay. Well, I'll get the information and I'll post it.
Yeah,
on.
post it on weekendappointment.com. We'll go from there.
Thanks a lot for your time.
No problem. 540-0580. Stephanie, you're on the air.
Hi.
Hello.
I live in a personal care boarding home, and one of these residents happens to be, he can be very hot-tempered, okay? And he likes to argue very easily, and he's always been disappointed with this one staff member that he deals with.
Okay.
So he keeps telling him he's going to sue him, and he won't have his job very long. I said to this guy, I said, look, you got to have a lot of money when you're talking about going into court suing somebody. And you don't have that kind of money.
Yeah, why does he want to sue this guy?
Oh, because he thinks he basically screwed, as he would put it, he screwed around with him. I guess he's not satisfied with some of the decisions that he made on his behalf.
Gotcha. Well, the answer is, if he wants to go find a lawyer and go out there and sue, it's what did somebody say to me yesterday? Anybody can sue anybody for any reason.
Yeah, but don't you? You have to have the income to pay the lawyer.
That's correct, and that may be what slows him down.
And I said to him, you know you don't have the money. Well, I'll talk to my brother, and he knows people.
Well, it sounds like a lot of huff and puff and blow your house down, but I think this house is made of brick, and I think we'll be okay. All right, hey, thanks for the call.
Okay, thanks.
That's very interesting. 540-0580. Listen, guys, I'm going to go to Lemoyne to the tobacco company today. Now, here's what I need you to do. At 3:30, join me there, and we're going to smoke some cigars. And I'm not buying, by the way. It's Dutch Treat. It's probably going to be Dutch's Treat if Dutch is listening. I hope he is. But we'll call it Dutch's Treat. Anyhow, long and short of it is we're going to smoke a cigar there at the tobacco company in Lemoyne. If you don't smoke cigars, just come out and pretend you don't even have to inhale. It's kind of like being a president overseas with marijuana. You don't even have to inhale. All right, guys, I will see you after the break. Well, welcome back. Carl Rominger here answering your legal questions. I've got Steve Snyder, and now we've got Vinny Manfredo as well from the office. I think everybody loves to call in here. Vinny, what's going on?
Not much, Carl. How's it going?
Good. What are you up to today?
I've got a jury trial on Monday, preparing for that, really.
Oh, okay. Okay, good. You should be ready. You should be well prepared, I'm hoping.
Oh, I will be, definitely. That's the key to winning.
It is a key to winning. I agree with that. And of course, Vinny, a lot of people don't realize how much time goes into a jury trial. I know when I quote people sometimes and they ask me how much it's going to be, and I give them a quote, they'll be like, but it's only going to be like a one-day trial. And I'm like, well, let's slow down for a second. For every hour in court, I've probably got 2 or 3 hours out of court minimum, and almost no trials one day, almost all are 2 days, even if they are short and sweet. So if you figure that out, you're looking at 16 hours. We'll be conservative and multiply it by 2, and you're already at 32 hours. So you're basically looking at a week's worth of work for a 1.5 day jury trial.
Oh, yeah, definitely. I mean, you're preparing for it the whole time, but once you know it's right around the block, you got to spend at least a day or two on it. And,
the other thing people don't realize is, and we had a caller a little earlier before you joined us. He said, well, I told the judge, just give me a little more time and I can get some documentation that'll refute what this guy's saying. Judges don't stop trials, particularly jury trials, to let you go get stuff. The judge goes, hey, if it was that useful or you thought it might be useful, and that's the key, you should have had it ahead of time. So a lot of times I end up pulling documents and witnesses that I never use because I have to anticipate what might come up.
Exactly. You have to know every issue that's going to come up so you can be prepared to attack it.
So, Vinny, I'm going down to Lemoyne at 3:30 to the tobacco company to smoke a cigar. I'm wondering, Steve Snyder may come over and join me. I know you've been known to smoke an occasional cigar, so you should come over and stop in and see us.
I'll think about it. Thanks.
Let's see. Joe, you're on the air with Carl, Vinny, and Steve. Hey, Joe.
Hello?
Joe.
Hi.
Yeah, what's going on?
The name is Joan. That's okay.
Oh, they didn't put an E in there.
Yeah,
Shane, what's the matter with you?
Well,
You put an E in Joan and it becomes Joe. Wait a minute. It doesn't even become Joe. All right, never mind. Anyhow.
It's good. Say, this Dutch treat, is that a Dutch master's treat?
Yeah. Well, listen, one of my Facebook
curious.
buddies, Dutch, I figure we have him by.
Wow. Hey, say, Carl, a very famous stogie man said, I took a hell of a lot more out of tobacco than it ever took out of meat. Do you know who that was?
Steve?
Yes.
Who was that?
Winston Churchill?
Exactly.
Okay.
Ring the bell for him. There's one other one.
Yeah, there you go.
There's another one you might know. A woman is only a woman, but a good cigar is a smoke. Who said that? I can't remember.
W.C. Fields?
Was it?
W.C. Fields?
I don't know.
It could
I don't know
be.
either.
Well, we'll run it through the callers here. Somebody will figure it out.
Yeah.
Someone
well,
will Google that.
you're sort of Dutchy, aren't you, Carl, like RJ?
Yeah. Oh, yeah.
A little bit?
Yeah.
Oh, that's good. Have a good time.
All right. Hey, feel free to come down and smoke one with us.
Okay, thanks.
All right. Bye. John. Is your name really John? John, you're on the air.
No, it is.
Hey, John, how are you?
Hey, thanks for taking the call. I appreciate it. Real quick question. I think I know the answer, but my son moved out of state, got a job, and bought a home, and lived there several years, and then moved back to Pennsylvania recently, and was fortunate enough to find somebody to rent his home.
Okay.
And so the question is, would that and the rent that he gets from his tenant only covers the mortgage? There's no gain on that whatsoever. It's covering it dollar for dollar. Would that property now, or his home, now be considered an income property?
Sounds like a tax question.
Well, it could be.
Yeah, I guess here. Let me jump in, Carl. This is Steve. He's going to have income, and then he'll also have expenses, the mortgage, and so he's going to have to count the income as income, and then the mortgage payment would be an expense, and of course he's going to be able to deduct the interest. So he's got income and an expense there. So I think for tax purposes, and I'm not an accountant.
And
but I think that's what you have.
And that's, of course, my concern is here's why, because there's probably some regulation somewhere or something also that may allow you, if you're going to rent something, that you might intend to return to a primary residence to get different treatment as well. But I don't know the answer to that. I also know it can affect the capital gains situation, because when you get the waiver of the capital gains tax on the sale of a personal home, you got to be able to certify certain things, et cetera, et cetera. So I would strongly urge him to talk to a CPA.
Okay.
All right.
Good. Hey, thanks for your call.
Hey, no problem. Thank you. Okay, who else we got here? We got some more. 540-0580. Call in. I got Vinny Manfredo on here. I got Steve Snyder. And, of course, if you guys ever want to hire us throughout the week, just go to RomingerLaw.com, or you can call the office at 241-6070, 241-6070. I've been told I got to say the phone number every time I say the website, because not everybody knows how to use their iPad, although some people are getting better at it. Dan, you're on the air.
Hi, how you doing?
Good.
Hey, I got a question for you. It's been, I think, like 5 years, pretty close to it, and I co-signed for a car loan, and the person I co-signed for filed bankruptcy.
Okay.
I do not have the car. How long is the statute of limitations that they can come after me for that car?
Well, it's 4 years for breach of contract.
But the issue is, when did the breach occur?
Yeah.
Well, apparently they didn't pay for the car months before the bankruptcy, so it's already past 5 years probably.
Well, then you should be in good shape.
Well, how long until they stop calling me on the phone?
Well, if they're still... I mean, we were just talking to another caller about this. They may be able to keep calling you on the phone to see if you're going to reaffirm an old debt. But you may be, and that guy was going to post something on weekendappointment.com, so I want you to do the same thing, so we get it there twice. Okay. And we're going to find out how the Fair Debt Collection Practices Act handles debts that are past their statute of limitation, and we're going to post the answer up there. But you got to post it on weekendappointment.com for me.
Yeah. Okay. We also put different articles on there as well, and since we're getting so many calls on the Unfair Debt Collection Practice Act, maybe in the next week or two I'll work on an article that outlines what that act does.
That would be helpful. All right, my friend.
Okay, thank you.
Not a problem. 540-0580. Call in. We'll answer your legal questions here on the air. Arthur.
Yeah, I got two answers, not a question.
Got it.
The first answer is, it was Mark Twain who said a woman is but a woman, but a good cigar is a smoke. The second answer you're looking for is on the rental income.
Yes.
The amount that he pays in interest on his mortgage is deductible. The amount he pays toward principal reduction will be considered by the Internal Revenue Service as income to him. These can be offset by the various expenses that he has with the property.
And he also can probably depreciate the property as well.
Yes, he can.
Okay. So, Arthur, I appreciate that. And that's the funny thing, too, when people forget that on a mortgage, when you have a 30-year amortization, for instance, that most of what you're paying up front is interest and some is principal. So, obviously, if you're on the front end of a mortgage, you're going to be paying more
deduction.
Yeah, you're going to have a better deduction than on the back end of a mortgage.
That is correct.
Yeah. Thank you very much.
That's all I had to say, my friend.
Thank you very much. That's why I appreciate when people can help us out. And thank you for helping us with the quote. Samuel Clemens, interestingly, wasn't a huge fan of Dickens, who's one of my favorite authors, but I really like both of them.
Yeah, they are both well worth reading in this day and age because we don't get literature like that anymore.
And somebody said that to me the other day. He said that the amazing thing about a lot of the old novels, and they didn't write that many back in the day, is that even if the stories are pretty mundane at the end of the day, or it's a kind of a well-worn plot twist or whatever, the quality of the writing of those time periods of the published authors was just amazing.
And you are correct there, because I just read Dickens on my vacation before last, and I forget which one it was. It was the kid who was the orphan who had rescued the prisoner and then went on. Oh, it was Great Expectations.
Great Expectations, Pip.
Yeah, it was Great Expectations, and I read that on my vacation before last.
I'm always rooting for Pip to live happily ever after with his princess.
That is a good thing to read. Okay, my friend, have a good weekend. Have a good day. We'll
All right.
see you.
Thanks. 540-0580, answering your legal questions on the air here. Keith.
Yes.
You're on the air, Keith.
I hate to contradict the guy, but the guy who wrote "A Woman Is Only a Woman, but a Good Cigar to Smoke" was Rudyard Kipling in a poem called "The Betrothed."
And when was that? Before or after?
After Mark Twain.
Interesting. Well, Shane, you're going to have to do some fact-checking here. You got all this. Here's what we're going to do. We're going to fact-check this later. We're going to get to the bottom of this, but you may be right, Keith.
Oh, I know I am, but
there
okay,
you go.
Thank you.
All right, thanks. Okay, see, now we're going to have to get the researchers in. Vinny, can you get to the bottom of that? Did you hear that quote? Can you find out where it really comes from?
I didn't hear the quote.
Oh, all right, I got to go to break. 540-0580. What is Vinny doing? Welcome back. Carl Rominger here, 540-0580, answering your legal questions on the air. I've got Vincent Manfredo, lawyer in my office, who's hard at work preparing for a jury trial, obviously not even paying attention to us as we talk. Steve Snyder, also a lawyer in our office, who likes to talk over me whenever he can. And let's see, Buck, you're on the air with all three of us. Buck.
Yes.
You're on the air. You've got three lawyers here, Curly, Mo, and Larry.
I need three lawyers.
All right. Tell us what's going on.
Listen, thanks for taking my call. Quick question. I have a couple apartment buildings, and the tenants, when they refuse to pay their utility bills, the bill falls back on me through the borough. Now, I did not sign any paperwork telling the borough to give these people their utilities. If they didn't pay, I would, but
no, it's just a law.
That's a law in Pennsylvania.
If you own the building, right?
Yes.
Yeah, and that's what they have. They have ordinances, local ordinances that basically say that the lien falls against the building if it's not paid by the tenant. And since you're the owner of the building, it falls to you.
So they pretty much got...
they got you coming and going. And here's the only complaint. The number one complaint I've heard is, how come the township let the guy get 6 months behind before they did anything about it, and now I owe for 6 months. I'd have kicked the tenant out myself if I'd have realized it, before they got way behind. So one thing I've counseled landlords to do is periodically query, if you have one or two buildings, periodically query the municipal services to make sure they're getting paid. Or collect them yourself from the tenant each month as part of the rent, or collect them as a add-on to the rent. And so, in other words, like I used to live in an apartment when I was in law school, and every month I would get a water bill as well as a rent bill. And it was the actual water bill. And that way the landlord knew that it was paid, and if it didn't get paid, he would know right away.
Well, one more quick question. The biggest problem I have, the electric bills get unbelievable because they're not using the furnaces, they're using space heaters.
Right, right.
Now, one of my friends told me, what you need to do is once it leaves the meter from the side of the house, it's your responsibility. He said you should have a cutoff switch installed. If the bill's not paid, block off the power.
Can't do that.
Can't do it.
Can't do it. Big trouble if you do.
Mm-hmm.
It's called self-help.
So you're pretty much at the mercy of the type of tenant you get in.
Yep, that's why you got to pick your tenants carefully. Can't pick your family members, but you can kind of pick your tenants.
It's hard to pick because some of the people I put in there were so nice, and the check.
Oh, yeah.
And,
trust me, just because somebody seems nice doesn't mean they are.
Well, they check out okay, and, I've always been somebody to give people the benefit of the doubt, and trust people. But, boy, once you become a landlord, you soon find out that is not the path to go.
Yeah.
You almost have to put yourself in a mean type of person, I don't know, just to scare the tenants into paying.
No, I don't disagree with you. I don't disagree with you at all. And you know what? I mean, that's the problem sometimes. All right, my friend. Listen. The best business people in the world are usually some of the meanest business people.
Yeah, listen, it's great talking to you. Appreciate your help. You answered my question. Now I'll just go pay the bill. Keep quiet.
All right. Well, Buck, and in the future, like I say, monitor it so he doesn't get behind. Also, just remind you, if you want to come down and join us to smoke a cigar, we're going to be going to the Lemoyne Tobacco Company in Lemoyne today at 3:30. I'm going to go right after the show, and I wanted to get as many listeners as anybody out there wants to join us. If you can't get there right at 3:30, come in. I'm going to hang around for an hour or so and smoke a cigar with me.
Well, it's been a while since I had a good cigar, but appreciate it, but I don't think I'll be able to make it today.
All right. Well, next time, take a rain check.
Hey, thanks a lot.
All right. 540-0580. Jeff, you're on the air. Jeff. Jeff.
Yes. I have a question on health insurance.
Okay.
Let's say an individual had an operation and they had their health insurance through the company.
Mm-hmm.
And say 6 months later, they get a bill from the hospital saying they owe money for the operation.
Right.
And then they call the insurance company up and ask them why that they're supposed to be covered. And then they give them some answer that, oh, well, we never got the paperwork filled out from you. And then the individual asks, well, you never sent the paperwork to me. And then they said, well, we sent it to your employer. He says, well, that's not me. I never received it.
Right.
So then they said, therefore, since they didn't get the paperwork in time, they're not paying for it again.
The insurance company's saying they're not going to pay for it.
Yeah. Yeah.
Huh.
In the meantime, the individual gets turned over to the bill collector.
How much dollar volume are we talking about here, brother?
50,000.
Well, then I think you need to get somebody on it to try to get that back under the insurance coverage.
Yeah. Right. But do I have any legal action?
Yeah, you might, and that's what I'm saying. That's enough money not to just sit on your hands. You need to go see a guy like Steve in my office.
Mm-hmm.
All right?
All right.
All right, Jeff, good luck.
All right. Yeah, all right.
Yeah, I mean, you have legal remedies, my friend. I'm sure of it.
Yeah.
Leslie, you're on the air with Carl, Vinny, and Steve.
Hello.
Hello, Leslie.
Hi. Hey, I'd like to know if an older person gets a divorce, and the woman makes more money on on her Social Security than the man, and that's the only thing.
Can you hold through the break?
Pardon?
Hold through the break here. Hold on. I'll get back to you. Vinny, you got to go, right?
I do. If anyone has any criminal questions, you could post them on your website there at Weekend Appointment. I'll try to answer them.
All right. And Vinny, of course, if they need to get hold of you in the office, then just call 241-6070. Guys, I'm going to be in Lemoyne at 3:30, but for the next hour, I'm going to keep answering your questions live on the air here. 540-0580. See you in a minute.